Coming to the second case, that is FMC Corporation and others versus Natco Pharma Limited, which was the judgment was given in Delhi High Court on 5th December 2022. So here the appellants is FMC Corporation and others, and defendant is Natco Pharma Limited. So the brief background of the judgment is of the cases. A division bench on Delhi High Court had discussed the application of doctrine of equivalence on the process patents. The present appeal arose from an impugned order dated 19th September 2022, where the single judge had refused to grant an interim relief against defendant's launch of chlorantraniliprole, that is CTPR. So FMC and Natco have a history of this CTPR patent litigation with each other. Previously, there have been multiple suits alleging that Natco had infringed FMC's patent. And the present order concerns one of FMC's CTPR patent, that is IN 298645. So the dispute is Natco stated that considering the history of litigation between the parties, it had sent a notice under section 105 to FMC, asserting that the process employed by them does not infringe the suit patent IN 645. Regardless, FMC had sued Natco alleging that it is using its patented method as claimed by claim numbers 1, 5 to 8 and 11 to prepare an identical product. So FMC has challenged that since both the competing methods describe an amide bond formation reaction to yield CTPR, they are equivalent. And on the basis of the doctrine of equivalence, Natco had infringed FMC's suit patent. So during the hearing for the suit, Natco stated that it shall not launch its variant of CTPR till the subsistence of other CTPR patent, that is IN 307 and 332, which are which expired in August 2022, and that its variant will not infringe IN 645. The patent, coming to the patent, the suit patent IN 645 is a 12-claim process regarding method for preparing N-phenylpyrazole 1-carboxamides and is used to prepare anthranic diamide insecticide. The method functions as a combination of 3 ingredients, that is carboxylic acid compound, an aniline compound, and a sulfonyl chloride to prepare or manufacture CTPR. So the single judge decision was the court appointed scientific experts, and relying on their findings or response, the court ruled out that the two competing processes were dissimilar. The court understood that FMC's process patents as mixing of a carboxylic acid and an aniline, whether with the base or a solvent, and thereafter adding sulfonyl chloride to the said mixture, and noted that while reactants could be combined in various orders, the method necessarily entailed the use of sulfonyl chloride with the mixture. So sulfonyl chloride was the main ingredient for the FMC's patent. However, the process used by Natco did not use sulfonyl chloride, and instead used another chemical, that is thionyl chloride, and it employs a different sequence of reactions. Accordingly, the court prima facie found out that the difference between the suit patent and Natco's process were not at all minor or insubstantial. So the division, the division bench order was later on given, that is FMC appealed against the above understandings and argued that though Natco process is not identical to FMC's process, by applying doctrine of equivalent, Natco had infringed the suit patent. It argued that the use of thionyl chloride instead of sulfonyl chloride as a reagent is an insubstantial variation, as sulfonyl chloride was not essential to the suit patent IN 645. Conversely, Natco argued that its process to manufacture CTPR is a two-step process requiring 2 reactors, and also the yield of the Natco's product is lower than FMC's process and does not produce any toxic byproducts. Lastly, Natco argued that doctrine of equivalence has limited applications in a method patent. So finally, the court's decision, the single judge, after examining the facts, concluded as the case of plaintiff is primarily predicated on doctrine of equivalence, and it is sought to be contended that even if Natco process does not literally infringe a suit patent, it may be found to infringe on the bedrock of equivalence. The contention of the defendant is that element-to-element test must be applied and tested on that anvil. And in the present case, there is no infringement since the reagent, that is sulfonyl chloride, is an essential element in plaintiff's process, and Natco process admittedly uses thionyl chloride as the reagent. which has different and distinct role in achieving the same task and accomplishing substantially the same result. So use of a different reagent and a completely different sequence of reactions in the Natco process cannot be termed as a minor or insubstantial variation so as to accuse the defendant of infringement and piracy.